Let me bring my guests into the conversation, and I'm so pleased to be joined both by Brian McDonald, who is the author of Safe Harbor. You may have caught some of his comments in open court this morning, and our good friend is with us, Gwen Lindsay Jackson, criminal defense attorney, and I hasten to add former prosecutor, lest we be accused of bias here on The Best Defense. So let me ask that question first. All right, and we're going to talk more about that documentation, what you found, and what will come out at trial about that. But Gwen Lindsay Jackson, drug abuse and or even just heavy usage and alcohol abuse don't necessarily rise to the level of insanity, do they?
No, it doesn't. However, in this case, it's a diminished capacity defense is what the defense attorney is trying to prove.
Now, and what's the distinction there? What does that mean for our viewers who may not know diminished capacity?
Simply stated, it just means that at the time that he committed the crime, he was in such a state of mind. In this case, he was so inebriated with drugs and alcohol that he could not appreciate what he was doing, couldn't stop what he was doing. So that's essentially the case. But time is going to be the key for winning on this, because, you know, if he's going in and out of this sort of state, a mental state, you got to prove that at the time he was at the house, not before, not flying on the airplane, getting there and renting cars, and not after, you know, making statements, you know, saying he didn't do it and whatever. But at the time that he was at that house, that he could not understand what he was doing. Did he take pills at that time? Did he, you know, did he liquor up? Did he have more alcohol? So I think that's going to be key and critical in getting that case established. It's very difficult.
And we're going to talk more about that, of course, with the author of Safe Harbor, and then also, Gwendolyn, with you about whether insanity is a viable defense. So let me come over to you, Gwendolyn, and ask you about this defense, and not so much in this case, but in general, because as compelling as it may seem here, we know, don't we, Gwen, that this kind of a defense rarely works in a court of law.
You're absolutely right, Jamie. It's very difficult to prove this case, even when you have a defendant that has an even more severe showing of a permanent psychosis. It rarely works. So what the defense attorney here is doing is he's not just relying on it to just knock out the murder, but he is, as you said before, he is trying to set the groundwork for some possible additional, you know, lesser charges. And, you know, he's setting a groundwork, so he's attacking it on all issues. It's a very difficult case to prove, and you got to prove that at the time that he committed this act, he was in that house when he picked up that knife, that he was unable to understand what he was doing, not before, not after.
Right. And of course, the prosecution wants to talk about before and after. They want to establish, as our 13th juror question suggests, that this was planned, that this was not an act of diminished capacity or insanity. And to that end, a lot of this is about the night. And let me bring in, Gabe, I hope you don't mind, my colleague, our colleague, Gwen Lindsay Jackson, former prosecutor, now criminal defense attorney. And Gwen, what do you make of all of this? I think it's good for the defense that this goes over until September, but I don't know. I kind of think put the prosecution's feet to the fire and watch it all fizzle away.
Well, in this case, I don't think it's going to fizzle away, because it looks like, you know, the way things are rolling, it just doesn't look like it will fizzle away. I kind of, as a defense, I like the fact that the judge was very clear about what the basis of the kidnapping was, the issue of inveigling and enticing. And obviously, if Mr. Grasso and, you know, his team can show that O.J. Simpson didn't do this, then he might have a shot. And he also has a good chance now of attacking that and focusing, as he said. And that, I think, would be a very good defense, because we know that that's the principal reason why O.J. Simpson may get life in prison.
Well, that's the big one.
More serious case.
Right. That's exactly right. That's exactly right. A couple of other significant charges against him, but if that one falls away, it's a much, I guess, easier case to defend. I hate to use that word with Gabe Grasso on the phone, because he's looking at the thousands of pages of discovery he's got to work with in terms of witnesses and evidence. And thanks to Gwen Lindsay Jackson for being with me on both cases, all cases that we had today. A big thank you to our correspondent Beth Karras, of course, reporting on O.J. Simpson. Banfield and Ford Courtside up next. First, I get the last word.